Nordby versus Raley.
Morning, Your Honor. Kim Peterson, Donnie Brand, Seymour Royer for the defendants.
Is Charles Nordby here?
He's outside.
Oh,
Kim Peterson.
right. Will you state your name, sir?
Charles Nordby.
All right, Mr. Nordby, my tender ruling was to deny reconsideration of your motion. So the appropriate discussion relates to whether I should reconsider the motion, not whether there was merit to it in the first place. It's whether I should look at it again.
Mm-hmm. Well, I wish you would, Your Honor. There was improper service, and this improper service, constitutes the whole case, really. It goes back to that. They served me with papers. Here we go. Okay. They served me with papers where a girl ran up to the door. She never knocked on the door at all to try to serve me, but she just threw them into the mailbox. Well, there's a law against putting mail in the mailbox without postage on it. So we returned it with the mailman, and 6 days later, it was returned to us. So then Mr. Glick notified us that they had set a certain date for a new hearing. Well, that date didn't constitute what the law said that it should constitute. So we didn't show up for the hearing because Mr. Glick had called my son and asked him about the date, and my son had told him that he had a power of attorney to represent me. So Mr. Glick says, "You don't have any power of attorney to represent your father in a court case," and he faxed him a letter to that effect. And then he turns around after telling him that, and he says, "Supposing we set this up for the 20th of January." And my son didn't have any power of attorney to authorize that. He never asked me. Mr. Glick never contacted me and asked me if January 20th would be a good date for the hearing. So I read in the law book where if you accept a hearing, then you can't complain about the service. And their whole case is based on a lie to you and a lie to me. In other words, they lied to the court by telling the court that we had requested a continuance to a certain day. We never requested anything from Mr. Glick. He just set that day up because he was trying to cover up their error in the service on this. Now, I have the envelopes here that shows that the envelope was delivered with no stamp whatsoever. That's a piece of evidence. Then it shows 6 days later the envelope being delivered with the stamp on it. And it just wasn't the kind of service that they're supposed to give. And this young lady signed a statement and turned it into you, which I have here, stating that she put postage on that letter. She's taken an oath that she put postage on that letter and mailed it to me. And this envelope clearly shows that she didn't put any postage on it at all, that she just jumped up and threw it in the mailbox. Then they state, in the very first sentence of the demur, they state that for 20 years, Charles C. Nordby has been harassing Raley's day in and day out. Charles C. Nordby, in 20 years, has sent Raley's 2 letters. Raley's wrote a book about their success in 1989. I read the book in 1991, and it really upset me because I saved Raley's from certain bankruptcy. So I wrote a book telling the true story of who saved Raley's. And it's certainly strange that Raley's has never tried to sue me for writing this book and exposing them in their lies. But anyways, in this book, it says that I have been harassing Raley's for 20 years. I've sent Raley's 2 letters, and that was in 1992 when I sent them copies of my book to their office. And I sent them a letter, and then I sent them another letter a little later on, just saying, "Don't you think it's about time that we get together and settle this case?" And that's the only 2 letters, sir, that I've sent them and contacted them about this case in 20 years, 1992. So that's a very bad statement for them to start off their statement by saying that I've been harassing Raley's. Now, when I went with Raley's, I was considered the leading specialist in supermarkets in California. I started in with Raley's, and I uncovered more than 80% of all their suppliers were cheating them, because Charles Collins, the president, and Jim Teal, the vice president, Charles Collins didn't have 1 day's experience in a supermarket. Jim Teal...
Mr. Nordby, I can't consider the validity of your claim today. I have to consider whether I should go back and look at the demur again, so I can't get into the merits of the case.
Okay. Mostly this was based on improper service, sir, and then they're lying about fixing postage onto this mail that they said they did and they didn't, and then they're lying to you about the fact that we had asked for a continuance. We never asked for any continuance at all. We never heard from them. So that's mostly what I have to say.
Ms. Peterson?
Yes, I'd just like to respond. No one in our law firm or Raley's have lied to the defendants whatsoever.
Mr. Nordby, I'm not going to grant the motion for reconsideration. I'm going to tell you, Ms. Peterson, that the first eight lines of your memorandum of points and authorities was outside of the pleading. It created problems that we're still dealing with. And while it's not a violation of law, it was, in retrospect, I think you can concede it's not very good judgment. There's no record before the court that Mr. Nordby's been pursuing any relentless campaign.
Are you talking about the demur?
I'm talking about, yes, on the demur. There's no record that supports the allegation that for 20 years he's been pursuing a relentless campaign against Raley's. It wasn't necessary for the ruling on the court's demur. It wasn't supported by the record, and it makes it more difficult to rule on legal issues when things like that are brought into the case. But still, Mr. Nordby, you haven't shown any legal justification for me granting the motion for reconsideration. So I'm going to uphold the previous ruling of the court. I'm going to direct Ms. Peterson to prepare a formal order denying the reconsideration.
Your Honor, I have an order right here. Would it be okay?
Submit it to the clerk and we'll take a look at it. Submit it to Mr. Nordby for review.
Make it clear that the hearing was within substantial notice, within the code and local rules, and that is sufficient. The only other issue I wanted to address is we have received copies of faxes that Mr. Nordby or his sons were sending to the Sacramento Bee and other attorneys around town. What it says here on this fax is that
Hi, this message is for Charles Nordby. This is Robert Strauch, S-T-R-A-U-C-H, from Downey Brand, Seymour, and Royer. And the purpose of this call is to inform you that there is an ex parte hearing scheduled for tomorrow, January 17th at 3 p.m. in Department 28 of the Sacramento County Superior Court. The purpose of that ex parte hearing is to get an order setting aside the default judgment obtained by you on December 13th, I believe is the date it was entered, against Raley's in case number 544344 in the Sacramento County Superior Court. If you have any questions, give me a call at 441-0131. Thank you.
Hello, my name is Charles Nordby, and I'm the man who saved Raley's from certain bankruptcy back in 1974.